Gun and illegal firearm offenses are one of the biggest areas in our law firm. When we deal with an illegal gun or firearm, there are several issues that we have to discuss in the office, especially involving a charge following a vehicle stop. And like a drug offense or a DUI offense, we want to focus initially on probable cause to stop the car, and probable cause to search the car. So let's look at the first issue, probable cause to stop. Now, if you watch my previous videos, you'll know that police must have probable cause to stop your car. And probable cause to stop is usually established through the officer observing a violation of the traffic code, like speeding, running a stop sign, running a red light, or some issue with the vehicle. Once police have probable cause to stop, they can begin an investigation which may recover perhaps an illegal item. Now, in this case, we're focusing on the issue of an illegal gun or firearm. So let's talk about that. So the next issue that your attorney wants to discuss with you is probable cause to search. Now, unlike a gun and a DUI, typically police aren't going to be able to establish probable cause to search based on some smell, because in a lot of these cases, the person's not intoxicated, and in a lot of cases, it's just the gun that we're dealing with. So there's no smell for the officer to really point to, which allowed him to actually search the vehicle. In this situation, there has to be some other issue that the officer has to document that caused him to search the car. Now, in Pennsylvania and New Jersey, don't forget that warrantless searches are permissible, meaning that police don't need a search warrant to search your vehicle, but they need probable cause to search it. Now, in the case of a gun or firearm, that can be established through either the sight or some type of observation or even movement of the driver. In a lot of situations, the officers see a portion of the weapon underneath the seat, which is what is known as plain view. And that allows them to obviously search and seize the car, seize the actual firearm just based on the actual sight of that weapon. In other cases, the officer will testify that the driver appeared nervous and he made what is known as furtive movements. It appeared to the officer as he approached that the driver was attempting to hide something or move things around in the car. And in addition, during the conversation with the driver, the officer may testify that he saw some type of bulge or some type of appearance of what appeared to be a gun based on his training or experience. Again, that would give the officer probable cause to search. So there's probable cause to stop, probable cause to search. If the officer finds a weapon, and obviously you don't have a permit for it, you're going to have an issue both in Pennsylvania and New Jersey. Now remember that a Pennsylvania permit has no legal power in New Jersey, meaning that if you have a permit to carry a weapon in Pennsylvania and you take it in New Jersey, you are committing a felony offense in New Jersey and subject to a mandatory minimum sentence. But going back to my example of the actual car stop, and focusing on the actual gun, one of the questions that your attorney should talk to you about is whether or not you had a permit to carry the gun. If you had a permit to carry the gun, obviously you are dealing with a completely different issue. But if you're in New Jersey and you have a Pennsylvania gun, you are still going to have a problem because, again, that's not a legal defense. But if the officer finds the gun and you don't have a permit for it, the next issue your attorney should talk to you about is, well, whose gun is it? If you are the owner of the gun and simply didn't have a permit to carry it and you had the gun in the car, the case isn't as serious as opposed to it being a gun that you simply bought off the street or from a friend. The next issue that your attorney should focus on is the actual characteristics of the gun. Was it loaded? Was it unloaded? The serial number, was it obliterated or removed? All these are very important and will increase the severity of the offense. If the serial number is taken off and the gun is loaded, obviously the law is going to infer that the person who possessed that illegal weapon was going to use it for some illegal purpose, and he was trying to hide the identity of the gun through those means. And obviously, it being loaded, it was in a position to be used in that way. Finally, your attorney should speak to you about the issue of constructive versus actual possession. And this is especially important in the issue of a gun or firearm. Where is the gun found in your vehicle? If it's underneath the driver's seat, as opposed to the passenger seat, well, that's a fairly big issue which your attorney should explore. If it's in the trunk of a car and the car isn't yours, well, again, there's an argument to be made that you didn't have constructive possession of the gun. Remember that constructive possession means that you know the item is there and you're intending and you have the intent or the power to use it. Whereas actual possession is, it's actually on your person. Finally, your attorney needs to speak to you about your prior criminal history, because again, this will influence the severity of the charges, whether or not you're eligible for a pretrial diversion program. Like in New Jersey, a pretrial intervention, or perhaps a Graves Act waiver. And in Pennsylvania, they have the ARD program, but in the case of a gun or firearm, that may be a difficult thing to achieve. For more information on gun defense in Pennsylvania and New Jersey, I encourage you to look at my website. There's a number of resources on the site. I have a book on the site, a number of articles focused on gun defense in New Jersey and Pennsylvania. They're very good articles. I look forward to seeing you in the office soon.